In Canada, employment laws are designed to protect both employees and employers. When an employer wants to terminate an employee, they are usually required to provide notice or pay in lieu of notice. This is based on the employee's length of service. However, there are exceptions to this rule. The most common exception is when an employer terminates an employee for just cause. Just cause refers to serious misconduct that fundamentally breaches the employment contract. This means the employee's actions were so severe that it makes it impossible to continue the employment relationship. Examples of just cause include theft, fraud, violence in the workplace, or serious insubordination. When an employee is dismissed for just cause, the employer is not required to provide notice or pay in lieu of notice. However, proving just cause is a high bar for employers to meet. They need to have clear and compelling evidence of the employee's misconduct to avoid potential legal issues. Just cause dismissals are reserved for the most serious situations. Minor infractions or poor performance typically do not meet the threshold for just cause. To determine if an employee's actions constitute just cause, employers must consider the severity of the misconduct, the employee's position, and any mitigating factors. For example, stealing a small amount of office supplies might not be considered just cause for a junior employee. However, it could be grounds for dismissal if the employee was in a position of trust, like a financial manager. Similarly, a single outburst at work might not justify immediate termination. However, repeated incidents of verbal abuse or threatening behavior could be grounds for dismissal. It's important to note that each case is unique and must be assessed on its own merits. An employer must carefully consider all relevant factors before deciding to terminate an employee for just cause. The burden of proving just cause rests solely with the employer. This means the employer must gather sufficient evidence to support their claim that the employee's actions warranted immediate termination. This evidence can include written documentation, witness statements, video footage, or any other relevant materials. Simply suspecting an employee of misconduct is not enough. The employer must conduct a thorough and impartial investigation to determine the facts of the situation. This investigation should include interviewing the employee in question, as well as any witnesses who may have relevant information. The employer must also give the employee a chance to explain their side of the story and respond to the allegations against them. Failing to do so could be considered a breach of the employee's rights and could jeopardize the employer's case if the matter goes to court. A proper investigation is crucial in any just cause dismissal case. It not only helps the employer determine if there is enough evidence to support the termination, but also demonstrates that the employer acted fairly and reasonably. During the investigation, the employer should gather all relevant evidence, including written documents, emails, and any other physical evidence. Interview all parties involved, including the employee accused of misconduct, any witnesses, and the person who reported the issue. Document all steps of the investigation, including dates, times, and summaries of interviews. Maintain confidentiality throughout the process, only sharing information with those who need to know. After the investigation, the employer should carefully review all the evidence gathered. If the evidence supports the claim of just cause, the employer can proceed with the termination. However, if the evidence is inconclusive or does not support the claim, the employer should reconsider the termination or seek legal advice. If you require an external investigation or surveillance to prove just cause, contact Duncan Investigations at 204-918-4203. We help employers prove their case.